Brilliance Audio presents The Case for Impeaching Trump by Elizabeth Holtzman, performed by Colleen Marlowe. The framers of our Constitution knew that someday there would be a president who would threaten the foundations of our democracy. They didn't know if his name would be Richard Nixon or Donald Trump, or what guise his misdeeds would take, but they knew that the American people would need a remedy. Waiting years until the next election to remove from office a president who engages in grave misconduct would pose a danger to the country. Thus, the framers provided for the removal of a president through impeachment, a centuries-old process with deep roots in British history. The grounds for impeachment specified in the Constitution are grave ones that strike at the heart of our system of government. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Treason is defined in the Constitution. It means levying war against the United States, or adhering to their enemies, giving them aid and comfort. Article 3, Section 3. Bribery, although undefined, seemed relatively clear. It was well understood by the framers, and is generally well understood now, though, as we will see briefly in Chapter 5, today's federal criminal law governing bribery is very cramped. But what are high crimes and misdemeanors? The phrase was added late in drafting the Constitution. When the framers first considered an impeachment clause at the Constitutional Convention in Philadelphia, they did not even debate before unanimously adopting a provision allowing impeachment for malpractice or neglect of duty. Later, however, some convention delegates had second thoughts. Pennsylvania's Governor Morris and South Carolina's George Pinckney pushed to strike the entire provision, arguing there was no need for impeachment, that elections would solve the problem. Virginia delegate George Mason scoffed. "Shall any man be above justice?" he asked. "Above all, shall that man be above it who can commit the most extensive injustice?" James Madison, who played a pivotal role in drafting the Constitution and served later as our fourth president, could think of many reasons for an impeachment provision. It was indispensable, he said, arguing that a president might otherwise pervert his administration into a scheme of peculation or oppression. He might betray his trust to foreign powers. Morris and Pinckney were beaten back. The impeachment clause would stay in the Constitution. A new version of the provision, closer to the one we know today, was offered, but solely for treason or bribery. Mason proposed adding maladministration, but his suggestion was rebuffed as too vague. He then suggested adding high crimes and misdemeanors to the impeachment clause. Why was he so persistent? He realized, and the framers ultimately concurred, that an impeachment provision that dealt only with treason and bribery was not broad enough to encompass the various kinds of serious harm a president could inflict on the country. Mason warned that there would be many great and dangerous offenses and attempts to subvert the Constitution that would not be covered by treason or bribery. These needed to be covered. To drive home his argument, Mason pointed to the notorious contemporary example of Warren Hastings, the British Governor-General of India, who was impeached by Parliament just a few months before the start of the Constitutional Convention. As Harvard Law School professor Cass Sunstein explains in his useful book, Impeachment, A Citizen's Guide, Hastings was accused of a wide variety of misdeeds, in particular personal corruption, maladministration, exercising arbitrary power, disregarding treaty obligations, selling favors, and engaging in fraud and corruption in making contracts. Mason worried that the behavior Hastings had exhibited, and with which the framers were immediately familiar, would not be impeachable under the phrasing of the constitutional provision as then written. He also pointed out that the Constitution banned bills of attainder, which the Supreme Court had defined as legislative punishment, of any form or severity of specifically designated persons or groups. Congress, Mason noted, could not punish such wrongdoing by a particular president. Thus, it is the more necessary to extend the power of impeachments, he argued. Mason wanted to expand the scope of impeachment to cover more kinds of executive misconduct, the kind that Hastings engaged in, and which a bill of attainder would encompass. He ultimately proposed adding to treason and bribery the phrase, "other high crimes and misdemeanors against the state." The proposal was adopted, though the words "against the state" were later dropped.